Trial. I'm not going to go into the specifics of that additional evidence, only to say that we presented a significant but small fraction of our evidence in this preliminary hearing.
And that is going to be key, because the defense highlighted some arguably significant holes in the prosecution's case against.
The cause of death is sharp force injury, and the manner of death is homicide. That is the official language. It is the first page of the Los Angeles County Medical Examiner coroner's report for Celeste Rivas Hernandez. The words are dry, bureaucratic, and definitive, a life reduced to a checkbox on a government form. But if you flip past the summary, past the clinical diagrams, and into the toxicology addendum, the absolute certainty begins to crack. There is a note buried on page 3 about the state of advanced decomposition interfering with a precise time of death determination. It's a technical footnote. It's also the first tremor in a narrative that, as of this recording, is built on a fault line. Think of a single blue plastic fragment, no bigger than a fingernail, sitting in a sterile evidence bag in a refrigerated locker downtown. It was allegedly matched to an inflatable pool found in a garage. That fragment is the silent hinge upon which an entire theory of dismemberment swings. But a fragment is just a fragment. It isn't a time-stamped video. It isn't a confession. It's a piece of plastic that will never speak, yet the state is asking it to scream for 12 jurors. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 91 because we don't just cover the story, we follow the evidence. We are examining the case against David Anthony Burke, the singer known professionally as D4vd, charged with the first-degree murder of 14-year-old Celeste. The preliminary hearing has concluded, and the judge bound the case over for trial. That is not the end of the analysis. That is the starting gun. The prosecution, through DA Nathan Hochman, has stated on the record that the evidence presented so far is merely a small but illustrative fraction of what they have. That is a promise made to the court. The defense, through attorney Marilyn Baklarz, has already drawn a blueprint of reasonable doubt by taking a scalpel to the gaps in that fraction. We are going to break down 7 specific evidentiary voids that could decide whether this is a death penalty case or a not guilty verdict. The evidence already decided.
Prosecution's case, the potential gaps. And the reason we're doing this is because we just went through the preliminary hearing. And this gave us a glimpse at some things. And even though, yes, the judge ruled there was sufficient evidence, there was enough evidence for this case to move forward, A, we know that the prosecution doesn't have to present everything they have at a preliminary hearing. And by the way, DA Nathan Hochman said what was presented by our office over the course of the last week is a small but illustrative fraction of the evidence investigators have accumulated that proves defendant Burke is guilty beyond a reasonable doubt of the brutal murder of Celeste Rivas Hernandez. And B, the bar is so low at a preliminary hearing, right? You just have to show sufficient cause to hold someone over for trial. It's a different story when you're trying to convince a jury beyond a reasonable doubt. Now, keeping that in mind, I get it that the prosecution didn't present everything. They don't have to, but there are some lingering questions. There are potential gaps in the prosecution's case that were highlighted by the defense or argued by the defense. And the prosecution may need to answer all of that at trial. Now, I actually listed a lot of these out when I interviewed DA Nathan Hochman on my News Nation show, Jesse Weber Live, the other night. And he said to me, his team is going to have the evidence to address all this. That he said this will be a strong circumstantial evidence.
Gap number 1 sits right at the threshold of the property. No independent witness has placed Celeste Rivas Hernandez alive inside David Burke's residence on the night of April 23, 2025. This is not a matter of witness credibility collapsing. This is a total vacuum of visual confirmation. LAPD Detective Corey Forrell testified that no surveillance video from the neighborhood captures Celeste entering the home. The Uber driver who allegedly transported her to the location could not, under examination, definitively identify the drop-off point as the residence itself. The driver could confirm a ride, but not the final physical entry. The prosecution presented a string of text messages discussing the address and a gate code. That is digital intent. It is not a visual fact. To secure a conviction for murder, the state must first prove presence. They must convince a jury that she crossed the threshold. Without a camera, without a neighbor's eyewitness account, the timeline of that night begins with a void of approximately 60 seconds between a car pulling away and an allegation of homicide. That space is a void the defense will fill with alternative narratives.
Detective Forrell confirms that there was no surveillance video of Celeste or David at the residence that night. There was no presentation of witnesses seeing Celeste enter that home on Doheny Place. And while the prosecution asserts that David arranged for an Uber to pick Celeste up that night to take her to his place, and reportedly there was a text conversation about that, including texts about the address, the Uber's arrival, the gate door being unlocked, apparently the Uber driver could not definitively say that he dropped Celeste off at this house. Detective Farrell testified that nobody saw Celeste get out of the Uber that night. No one testified, as of yet, that they saw the killing or watched Celeste die. There were no witnesses called regarding that specific 20-minute or so period of time, that window at night when prosecutors believe Celeste was murdered after allegedly arriving at David's place. Now, what could the prosecution do? They could couple the text message exchange between Celeste and David with location data on the phone, potentially map it to the purchase of items from David afterwards, or allegedly from David afterwards, and use the allegation that there is no more activity from Celeste's phone to put out a timeline of when she allegedly arrived and when she was allegedly killed. That's how they even get to that 20-minute window. And yes, cases can be brought and won on circumstantial evidence alone. You and I both know that. You don't always need direct evidence like surveillance footage or an eyewitness.
Gap number 2 is the complete absence of a mechanical cause of death. The deputy medical examiner, Dr. Grant Ho, testified that the cause of death was multiple penetrating wounds. But on cross-examination, Dr. Ho conceded he could not rule out the possibility that the 2 penetrating wounds occurred within seconds of each other, nor could he state with medical certainty that the wounds were inflicted by another individual.
Assuming she goes into the house, what happened? How do you know it was first-degree murder with special circumstances? Neither Detective Farrell nor the deputy medical examiner could precisely say what happened. And that is complicated by the fact that no murder weapon was ever recovered. And to give you an idea of what I mean, you go to the cross-examination of Dr. Grant Ho, this deputy medical examiner that I mentioned. This is when the defense was questioning him, because the defense asked if advanced decomposition, which we have in this case, can affect the accuracy of drug results in toxicology testing. The witness says potentially. The defense asked if it's helpful to know whether a person has a mental health history, whether they're suicidal, whether they're a habitual drug user while preparing an autopsy report. The witness says potentially. Dr. Ho didn't apparently speak with relatives about these characteristics or potential characteristics. And the defense, as far as we could see, seemed to insinuate on cross-examination, is it possible that Celeste may have stabbed herself, that she may have done something to herself? You know, defense attorney Marilyn Baklarz had Dr. Ho establish that he cannot rule out that the 2 penetrating wounds, which he claimed were the cause of death, occurred within seconds of each other. Quote, you cannot determine whether Ms. Hernandez was holding the knife that caused the 2 wounds, correct? Correct. You can't rule that out, right? So that is a consideration, but we would expect to find hesitation marks. And then he was asked, is it fair to say that you don't know the circumstances under which these wounds occurred? And he replied, correct. Assuming, of course, it's a knife, right? We don't have the murder weapon. That leaves room for reasonable doubt. That leaves room for the defense to explore. And we have to imagine the defense could bring in their own pathologist to testify to maybe a different cause of death.
This isn't malpractice, it's physics. In a body where advanced decomposition has set in, the absence of defensive wounds on the surviving tissue doesn't automatically prove passivity, just as the presence of deep wounds doesn't automatically prove a struggle. Dr. Ho was asked directly if he could exclude self-infliction. He replied, correct. You cannot rule that out. The defense seized on this immediately. They did not claim Celeste harmed herself, but they asked the question the state cannot answer with hard science. Why? Because no murder weapon was ever recovered. Which brings us to gap number 3. We don't have the instrument. The prosecution alleges dismemberment via chainsaw.
Of human remains, detectives testified about these chainsaws, a mop system, cadaver bags, a blue inflatable pool that were all allegedly ordered to David's home using an alias in the days after Celeste's reported death. How a DNA expert testified that evidence from apparent blood stains in the home's garage were consistent with a DNA match for Celeste, that you had a criminalist testify about mats at David's place that had linear cuts and stains that tested positive for possible blood, evidence of an alleged trash bag with stained wipes, alleged cuts to this blue inflatable pool, how blue plastic fragments found in Celeste's remains are allegedly consistent with the inflatable pool that David reportedly ordered and that was found at David's place. That David's Tesla, where Celeste's remains were found, reportedly had 11 air fresheners in it. How testing found possible traces of blood in the car. Silverman suggests that blood could have leaked from the parked Tesla, soaked through the rubber mats, and reached the bricks underneath. And what about the testimony that allegedly right after this supposed killing, during the night of the 23rd into the morning of the 24th, digital data allegedly shows the Tesla traveling to Santa Barbara. That Celeste passport card was allegedly found in Santa Barbara County. Now, I say all of that to say that the prosecution definitely has evidence in this case that will challenge.
3 chainsaws were ordered to the residence. 2 were found in the garage. A forensic criminalist testified that the 2 recovered saws did not test positive for blood or human DNA.
Of an alleged murder weapon. What exactly did David allegedly use to dismember Celeste? Because prosecutors allege that David ordered 3 chainsaws to this home, but the 2 that were found in the garage in this residence didn't test positive for blood or DNA. Same for an electric saw that was found. There was testimony suggesting that a criminalist posited that if the blades had been used for human dismemberment, they wouldn't have been able to be cleaned to a point where their testing would have resulted in a negative result. And what I'll note about that is the deputy ME, Dr. Ho, testified that certain dismemberment is potentially consistent with chainsaw cuts. So what's the disconnect here? Well, one of the things prosecutors talked about was this 3rd missing chainsaw. And they presented product photos of this Makita brand 10-inch chainsaw, apparently from Home Depot, apparently delivered by Postmates. But detectives confirmed that the chainsaw wasn't at the place. As far as we can tell, they don't have it. I mean, is this the one? Is this the one that he allegedly used to dismember?
The state's own expert posited that the blades, if used for such a purpose, could not be chemically cleaned to the point of invisibility to standard forensic testing. This creates a paradox for the jury. Either the biological material degraded beyond detection, possible but debatable, or the 2 saws in evidence are not the tools of the crime. That forces the state to argue the 3rd. Missing Makita brand chainsaw is the smoking gun. But a smoking gun that cannot be found is just a receipt. A Home Depot order form does not mutilate a body. A human hand holding a blade does. That missing tool is not lost. It is a permanent negative space in the courtroom's physical narrative. Gap number 4 is the alibi text. At 10:31 p.m., a message is sent from David's device to Celeste's phone asking, "Where are you at?" The state labels this an immediate cover-up, a calculated performance by a killer who knows the victim is already dead in the next room. The defense paints a different picture: confusion. Look at the digital pulse of that night. After this alleged murder window, the defendant's phone sends not 1, but a dozen messages to the victim's device over the following hours. If this is a staged alibi, it is excessively verbose. It breaks the mold of the cold, clinical killer who disengages. A prosecutor will say it's method acting by a sociopath. A defense attorney will argue it's the erratic behavior of a person who didn't know a death had occurred. The message log doesn't read like a script. It reads like a one-sided conversation that continued long past the point of a logical cover-up.
Highlight a few things that came out in the preliminary hearing, because the prosecutors claim that at 10:31, so the night that she comes over, the night that they claim he killed her, he sends this alibi text. Uber said, "You're here. WYA." Where you at, right? Hello, bro, all these texts. And Detective Farrell testified that the texts from David to Celeste continue that night, that there's around a dozen texts from David to Celeste after her Uber arrival, after she arrives at the home. This is the allegation. Again, all about David purportedly confused about her silence. And Farrell testified that there was no additional activity from Celeste's phone after she arrived. Why? The allegation would be because she's dead. And Farrell testified that David's Tesla, the phone, left the Hollywood Hills residence around 11:30 p.m. to make these purported Santa Barbara trips, right? Farrell says the defendant's last text message to Celeste to her phone was April 26, 2025. So this was the day after his album Withered was released. So you have two things, right? You have no more activity from Celeste's phone. David never texts her again. They would argue suspicious. They would say he really has nothing to do with this and he just never contacts her again.
This is where the narrative turns into a thriller. If David Burke was panicked, blundering, and sending texts after the fact, how do we explain the state's allegation that he waited for her to bleed out? The prosecution's own filing contains the specific language that the defendant stood by while she died, but the timing window for that act is allegedly only 20 minutes. Consider the forensic reality. If the medical examiner can't pinpoint the hour of death due to decomposition, how can the state pinpoint the psychological state of the accused during a once 200-second window with no eyewitness, no recording, and no weapon? The the real question isn't who sent the alibi text. It's how do you prove standing over a body with a stopwatch when the autopsy report can't even tell you which month the heart stopped beating? The evidence already decided. Gap number 5 is the motive inversion. The state argues financial gain and the silencing of a witness. David's debut album, Withered, was set to release on April 25, just 2 days later, under a reported a $19 million deal. The threat to expose a statutory relationship placed that fortune at risk. That is a clean motive. But the defense introduced a counter-narrative of hostility flowing in the opposite direction. Text messages written to the record paint Celeste as demanding, not fleeing. On April 22, a message allegedly arrives from Celeste threatening to end David's career, to tell her father so many lies, and specifically using the phrase, "I will damage anything." Another message references ending his life.
Were highlighted by the defense on cross-examination of Farrell. They arguably show that Celeste was demanding to see David before he traveled abroad, that she begged to see him in person, that he tells her no. This would defeat the narrative that he allegedly lured her to the property to kill her. And then Detective Farrell seemed to confirm that David says, okay, agrees to see Celeste on April 23rd, 2025. And after she sends him this text, cut this S out, I'm seeing you today. Now, Blair Burke, David's attorney, reads this allegedly threatening text from Celeste that was dated April 22nd, allegedly telling David that she will end his career and tell her father, quote, so many lies about him, that she's going to mutilate his quote, I will tell my dad so many bleeping lies about you, dead ass. I will end your career and your life. I will damage anything. She allegedly sent this on April 22nd. Now, Burke apparently also read a text from Celeste explicitly threatening to make anonymous accusations and, quote, leak all that S I got on you. And this is apparently in reference to whether or not David was going to post on Asia Collins' social media accounts showing the two of them together. There seemed to be an insinuation that she was jealous of this person. Asia Collins is somebody who we've talked about before, apparently in David's orbit. And Celeste apparently told David she has his contact information, his mother's number, threatening to release all this information. And then you have texts like this where Celeste allegedly wrote to David in August of 2024, I care about you. I killed my kid for you. I don't like talking about it because it gets me really upset, but I do anything to have it back. So why does this matter? Why is this all important? Well, here's the point. Yes, the prosecution can point to messages like that to say, yeah, she was threatening to expose him and ruin his career. He had a motive to kill her. So to protect his career, he lured her over and he killed her. After all, the prosecutors say his debut album, Withered, that was part of a $19 million deal with Interscope Records, that was set to release just a few days later on April 25th. So it goes to the special circumstances allegations, a part of the murder charge, right? That would lead to more severe penalties, possibly the death penalty, killing for financial gain, killing a witness, lying in wait, special circumstances, right? But the defense could also argue that she was the one who initiated this, that she begged to come over, that she became hysterical, that she became erratic, that she had mental health issues, and that she did something to herself that night. That maybe she attacked David. That maybe he engaged in self-defense. Did she attack him? Did she threaten him? Will he take the stand and argue that? Was it a heat of passion killing, right? Is this manslaughter? Heat of the moment, not a premeditated murder. Is there an area for reasonable doubt? Because we don't have more information right now about what exactly happened in that 20-minute window, allegedly behind closed doors between Celeste and David, when she allegedly arrived at the home and when David is accused of sending an alibi text, right? They say 20 minutes or so after she arrives, he sends an
This is not a victim cowering in fear of a predator silencing her. This is a volatile, emotionally charged interaction where the deceased is the initiator of the threats. This does not make the defendant innocent, but it alters the legal landscape. If the victim is the aggressor, first-degree murder with special circumstances for lying in wait becomes harder to sustain than a lesser charge of voluntary manslaughter in the heat of passion. The defense is not building a wall of innocence. They're paving a road to a lesser-included offense. Gap number 6 is the toxicology and mental health blind spot. The defense's cross-examination of the medical examiner revealed a startling lack of context. Dr. Ho did not consult the family regarding Celeste's mental health history, prior suicidal ideation, or substance use history before finalizing the autopsy report. He agreed that such information is potentially relevant to determining the manner of death. This isn't a character assassination, it's a foundational challenge. If the toxicology is muddled by advanced decomposition, which the witness conceded is scientifically possible, and there is an unexamined mental health component introduced via text messages discussing severe emotional distress, the defense has a platform to argue an accidental or self-destructive event. The state has the body. The defense has the biography. A jury often needs both to convict. Gap number 7 sits in Santa Barbara County. We know the Tesla traveled north, We know a passport card was discovered there. The state's theory implies David disposed of evidence during these night drives. Yet, the timeline presented by Detective Forel only sketches a vehicle in motion. There is a critical absence of testimony regarding digital forensics between April 23 and the eventual discovery of the remains. We do not have, in the preliminary record, an associate who confirms the defendant acted alone, nor a witness to the dumping of the remains. The missing chainsaw might be in the San Ynez Valley, or it might not. Private investigators have already publicly speculated about whether the tool was disposed of near Cachuma Lake.
Well, the medical examiner said, because of the state of decomp, they can't say for certain exactly like how long of a blade or sharp instrument that was or whatnot. And listen, I think everybody assumes it was probably a knife, but there was a lot of time that passed in between. So it's mind-boggling to me that there was any evidence such as pool or anything still in that garage. I mean, the stupidity, right? If you're trying to cover this up. And part of me wonders, if he just knew he was going to get caught and was just kind of waiting. Because this was
Do you think the missing chainsaw is the key?
Yeah, I think that chainsaw might be in Santa Barbara.
Really?
I think on the second or third trip, I think he could have been, getting, because if you look at that second trip, they're contending that it happened around May 5th, around Cinco de Mayo. And May 8th, I think he took another trip up there. And that makes me wonder if it was to dispose of things near that lake or something. But I don't know that for sure. I just think that could be a reason that the ID was ultimately found up there as well. It's like a disposal spot. But why he picked that,
That's speculation. A gap is not evidence of innocence, but a gap where a tool should be is a reasonable doubt factory. The Tesla's GPS says the car moved. It doesn't say what was thrown from the window. The prosecution promises more evidence is coming. DA Hochman stated, "We presented a significant but small fraction of our evidence." That is standard prosecutorial language, but it also carries an admission the House of Cards requires cards we haven't seen yet. We haven't seen the testimony of Asia Collins or the other associates who smelled decomposition.
Prosecution's filing, prosecutors alleged that David lied to friends and associates about the alleged smell of decomposition at his home, at his residence. But I don't recall anyone testifying to that. We didn't see Asia Collins. We didn't see Neo Langston testify, purported friends, associates of David. I mean, you go back on July 4th, 2025, according to TMZ, there was a live stream that apparently showed David telling his friends, Neo Langston and Usgana, about this smell in his house, saying he apologized for how his bathroom smells, claimed that he went to the bathroom 2 hours earlier.
We haven't seen the full digital extraction of the iPhone. The defense countered in closing arguments that the evidence only shows the transportation and concealment of a body, not a premeditated killing.
Maybe. I just go back to what attorney Bednarski, defense attorney, said to the court at the prelim. After days of testimony, the evidence only shows a young woman's body was transported and concealed. And while this circumstantial evidence supports concealment of a death, it doesn't support a killing or the requisite intent, forethought that would make it first-degree murder, that the law recognizes two forms of malice. And her argument was neither. And then if you don't have either, there's no murder. Express malice was a deliberate intention to take away a life, and she argued there was no evidence showing deliberate intention here from David. She argued there's no statement of intent anywhere to harm her. There was no history of violence or hostility from him to her. How the relationship, the evidence listed here, is the opposite of homicidal malice. She also argued there was no implied malice. There was no considerable provocation. And she says, counter that, if you look at provocation, it was from Celeste to David, that she was the threatening one. She argued that the three special circumstances allegations that would make this first-degree murder charge eligible for the death penalty are unconstitutionally vague. How lying in wait, you look at the text messages that were presented.
They argued the special circumstance of murder for financial gain has no California precedent for anticipated future earnings. That's a bold legal strike. It suggests the death penalty eligibility itself is built on sand. The arraignment is set. A formal reading of the charges is on the schedule. Between now and a trial date, the Seventh Amendment demands the state fill these voids. But if the gap is physical, if the murder weapon never surfaces, the state must ask a jury to convict on a story alone. And a story, no matter how horrific the photos of the aftermath are, is just a vibration in the air. The evidence already decided. Before you close this tab, I'm directing you to the specific medical examiner's report filed with the Los Angeles Superior Court. Look at the toxicology footnote regarding decompositional interference. My question for you to answer in the comments is simple. If the science cannot tell us when she died, can the law tell us who to blame? Thank you for watching Crime Files 9 Hila 1. Make sure you like, share, and subscribe with notifications on. We don't just read the headlines. We wait for the docket to update.